afternoon and thank you for joining us. I'm Ramona. I'm a solicitor at Thrings Solicitors based in Swindon. My colleague is Abby, an associate at Thrings and one of our rising stars in intellectual property world. I also head up our business growth unit, which in a nutshell aims to support business growth for our local SMEs. I'm going to hand over to Abby now to canter through the world of IP, of which she's an expert. So I'll be on hand to raise any questions and to generally interrupt and annoy Abby. Abby, over to you.
Thank you, Ramona. So yes, we're to be here for the Swindon and Wiltshire Local Enterprise Partnership Conference. And we are going to be talking to you today about how to identify your intellectual property assets brilliantly. So Ramona's just mentioned that she's a partner in commercial disputes and heads up our business growth team here at Thrings, but I'm an associate commercial solicitor and I am passionate about all things terms and conditions, websites, branding, and intellectual property, which is why I'm speaking to you today. So if we were together in person, so it's the afternoon, and hopefully if we were in person, we'd be having some nice sandwiches and afternoon tea bits and bobs, I would be saying to you, welcome everyone to our, webinar or seminar if we were in person. We hope you're enjoying your refreshments, sitting comfortably on your chairs, looking forward to this protected presentation that you can't tell anyone about. And you'd probably sit there and think, wow, that's a bit of an unusual and quirky introduction, but bear with us because there's a lot of intellectual property in that introduction and we're going to talk you through it. So we hope you're enjoying your refreshments. So if we're drinking tea or coffee, or maybe there was some soft drinks on the table, then we would be possibly drinking Twinings tea, Nespresso coffee, Coke and Diet Coke, maybe some Buxton water. And all of these brands are trademarks. So, as just mentioned, your brand is a trademark and you can have registered trademarks or unregistered trademarks. And a trademark can be quite a variety of things, actually. It can be just the word, it can be the logo, it can be a shape, sound or colour. And on the screen there, you can see a nice Ferrari Testarossa, I think that is. But Ferrari, for example, have managed to trademark their famous red. I don't know if we've got any Star Wars fans listening today, but the sound of the lightsaber, I can't even do it. I'm not going to
do it again.
I'm not going to, no, it's not there, is it? But the sound of the lightsaber is protected as a trademark. We've got the famous McDonald's golden arches there as well. But their slogan, I'm loving it, is also a trademark. And also their little jingle, da 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 da, I'm loving it, is a trademark too. And back in the day, probably showing my age a bit now, but Direct Line, you know, the telephone, little telephone on the wheels, it used to go over the hill and it used to be da 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 da. That was also a trademark as well. So when you have a registered trademark, they are territorial in scope. So wherever you trade or the countries in which you trade, you should seek to have trademark protection. So if you do business in the UK, you should apply for a UK trademark. If you operate in more than 2 countries in Europe, bearing in mind that we've now Brexited, you can apply for a European mark, and you can also apply more widely across the globe as well. So when you apply to register your trademark, you have to specify what goods or services you offer to your customers under that brand. Now, what the intellectual property offices across the globe have done is, because there are so many different types of goods and services out there, they have categorised all the goods and services that we could ever think of into 45 different classes. So goods fall under classes 1 to 34 and services are 35 to 45. So just off the top, giving an example, if you're a software company, perhaps, you know, writing software, you might want protection in class 9 for software, And if you were a training course provider, you might want to, that will probably fall under class 41. Okay. So a trademark is yours forever, which is great because the law typically doesn't like us to have too many monopolies, but it is yours for life and you have a monopoly to use your brand name as long as you renew it every 10 years for a fee. So you submit your application via the Intellectual Property Office, which is the kind of government organisation which oversees intellectual property in the UK. And it's quite cost effective, actually. So if you do it online, you pay a fee of £170, and that £170 includes your first class. So again, taking the software company as an example, that would include class 9 for software. And then if there's any other goods and services that you want to protect, but they fall into different categories or classes, so say that the software company also does training, they would need to register in class 41, possibly class 42, and that would be an additional £50 for each additional class. So we fill in the application where we put details about, ownership, so your business as the owner. We upload an image of your logo or the colour or the sound, whatever it is we're trademarking. And then we send it off to the IPO. And then someone at the IPO will receive the application, an examiner, and they will just go through the application and make sure it meets the trademark criteria. And everything's okay with the application. So in a really simple summary then, the only time when a trademark really isn't going to meet trademark criteria is if it's generic or descriptive. So Apple were able to trademark their brand for mobile phones and computers and tablets. But if Apple were a greengrocer selling apples, then it would be descriptive of what they sell or what they do, and they wouldn't be able to trademark it. The examiner at the IPO will also let us know if there are any similar trademarks out there which already exist using similar services, and let us know about it. And then we can take your lawyer or your legal advisor will work with you, or if you're doing it yourself, you might just want the application to proceed and see where it goes. So once the examiner gets the go-ahead from us to proceed, then they will put the application in the trademark journal for a period of 2 months and 2 weeks. And the trademark journal, I've put a link on the PowerPoint slides there. It's basically it's a website page where all the trademark applications go, so that brand owners can keep an eye on it and oppose your application if they feel that your logo or your brand name is too similar to their existing brand. Oppositions, according to the IPO, are relatively low. Only about 1 in 20 applications are opposed. And again, your legal advisor can work with you to chat through any risks. But if no objections are received from existing brand owners, then your application will proceed to registration and you will get emailed a nice registration certificate.
Abby, if someone objects to it, would you have a chance to slightly tweak your application to then allow it to go through, or do you have to start again?
Absolutely. So if you have a reasonable business opposing your trademark, then because some businesses or brand owners are more aggressive than others. So if you've got, a pretty decent business on the other side, they might just say, look, we're opposing it, but all we want you to do is, can you not get protection in this class, or can you just tweak the description of the goods and services a little bit, and hopefully you will be able to negotiate and come to an agreement so that both brands can coexist together. Okay. So continuing with opposition, I wanted to talk to you about Oasis and Oasis. So we've got Oasis the band, we've got Oasis that once upon a time was a clothes store. I'm not sure if it's still going. And we've also got Oasis the drink. And the reason that these brands can coexist, even though they're exactly the same name, is because they all do completely different things and will be registered in completely different goods and services and class numbers. But as I just mentioned to Ramona, that doesn't stop a really aggressive brand or company who's got a lot of money to you know, have a go. They will have a go if they've got enough money to, basically. And an example of that, I can't remember his surname, but there was a comedian called Joe, and he changed his name in protest to Hugo Boss, because Hugo Boss, he's changed it back now, but Hugo Boss went on a kind of a bit of an aggressive campaign, and there was a microbrewery, I think it was in Wales, who had the name Hugo in their name, and Hugo Boss, the fashion brand, got really funny about it, and the microbrewery, I think they just caved in the end, or for whatever reason, they were a startup microbrewery, they perhaps didn't have enough money to fight it, or maybe they took, you know, bad legal advice. But realistically, I don't think anyone out there is going to get confused between Hugo Boss, a fashion brand, and a microbrewery called Hugo. But yeah, but just watch out for those aggressive types. Easy Group, as in EasyJet, Stalios, they're quite aggressive too. But there we are. Oh, Mythbuster. We love a good Mythbuster here at Thrings. So if you see a brand name and after the brand name or the logo, it's got the R in the circle, this means that that brand name is a registered trademark. And please, 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 please do not use the R in the circle after your brand or logo if you do not have a registration certificate, because it's actually a criminal offence to use it if you don't have a registered trademark.
Gosh, I didn't know it was a criminal offence. Gosh.
Yes, it's very naughty. But there is, you know, there's a big kind of misconception out there that if you use the TM, that means that you have a registered trademark. So if you don't have a registered trademark, then you can use the TM, and most people think this means registered trademark anyway. So TM is perfect to use because one, it acts as a great deterrent, because most people think that it means that it's registered. But another positive to it is that if your trademark doesn't quite meet registration criteria, so you can't trademark it, perhaps it's descriptive of what you do, then you can still use the TM symbol. And again, it's a perfect deterrent. So just something to be mindful of. Only use the R in the circle if you've got a registered trademark.
So Abby, that's really useful. How long, if you were going to try and register it, your mark, your brand, your logo, your sound, your paint, how long would the process take, do you think, on average?
Well, pre-Brexit, well, the opposition period is 2 months, 2 months and 2 weeks. And so pre-Brexit and pre-COVID, it would from start to finish, it would probably take about 3 months to get your application in, go through the process and get your registration certificate. However, because we've Brexited, the UK IPO had to create kind of a unique protection for brand owners with European Union marks who once had protection in the UK, but now they don't because we've Brexited. And then COVID happened and the IPO shut down for several months as well. So the IPO are kind of playing catch up at the moment because they're still creating those protections for ex-EU brand owners, creating those unique UK protections. And they're still catching up on applications during the COVID period. So what I would say to anyone is if you are thinking about applying to register your logo or your brand name or whatever it is as a trademark, get in there as soon as you can, because the whole process is taking about 6 months. So whilst the opposition period is still 2 months and 2 weeks, it's just not going to get in front of an examiner for a few months, and then the opposition period will start.
That makes sense. Thank you. So I guess if people are listening and are interested, they need to get on sooner rather than later.
Absolutely.
Mm.
Okay. So we hope you enjoyed your afternoon tea. So that was all about branding. We hope you're sitting comfortably on your chairs. And I've put some really unusual chairs up on the screen, because sitting comfortably on your chairs is all about design right and registered designs.
I'm not sure it's possible to sit comfortably on the one that looks like it's got sticks sticking out.
Yeah, I was thinking that. I think you'd have to be pretty tall to sit in that one. Otherwise, your dangly little legs or your kids' legs are going to get spiked. Okay, so similar to trademarks then, designs can be registered or unregistered. And again, they are territorial. So wherever you do business, you should seek advice about protecting or registering your design in the UK if you're in the UK, and in Europe and further afield too. So unregistered design is also known as design right, and that's something that arises under English law. So what's the difference between the two? Generally speaking, registered design protects the look of something that's quite nice to look at, aesthetically pleasing. So its appearance, its decoration, patterns. Think wallpaper designs. Fashion designers sometimes do their clothing designs. And I've put the example on the screen here as Twinings have actually registered their different flavoured teas as separate registered designs. Whereas design right protects the shape of something. So it's not necessarily, you know, nice to look at, but it will protect the physical shape and how the parts of that product or design fit together. So what's the registration process for registered designs? So the only requirement is that your registration must be new and have individual character. 99.9% of the time, you're going to tick that box. So nothing to be too concerned about. It's an online application, again, similar to the trademarks, but registered designs are so cost effective. So it's £50 to protect one design. But if you've got 9 more, you only pay another £20 and you can protect up to 10 designs. If you've got another 10 more, then pay another £20 and then you can protect all 20 designs. So these are so cost effective. So an example, I acted for a jewellery designer and they had just brought out a whole new range of necklaces. The necklaces weren't similar. They all had different jewels or different features to the necklaces, but we could all like wrap it up in one design application. They're so cost effective. So again, you fill in your application form and, you know, who's the owner, when was it created, and you would have to upload your illustrations. So if it's a product or packaging, I would probably take pictures of front, back and the 2 sides, but you can upload CAD drawings as well, as long as they're in the right format. And again, if you register your design, you prevent anyone else from using it for 25 years, subject to you renewing every 5 for a fee. The registration process is super quick. And again, pre-COVID and pre-Brexit, I could put in a registration application in the morning, and sometimes I would even get a registration certificate by the afternoon.
Gosh.
So super quick, super cost effective, but I would probably say they might be taking a little bit longer, again, because of the trademark backlog. I'm not sure how, if the kind of registered design team are affected at the IPO. And again, perfect deterrent having a registration number. You can put it on your website, on your marketing materials, on your packaging, and on the product itself. Sometimes on plastic products, and I've seen it on toys, you normally get like a raised bit which has the registration number and details about the manufacturer. And like I said, it's the great deterrent if a competitor or anyone feeling influenced by your design, that it might make them think twice.
I was going to say, so when you say great deterrent, you mean from copying it, essentially?
Yes, great deterrent from people trying to copy your design, and yeah. Okay, so unregistered design, known as design right, it's not quite a patent, which is an invention, and it's not quite a registered design, which is generally nice to look at or something nice to look at. It protects kind of boring objects. So I've put an example here of hot water bottle, boring but so essential this winter, and a hospital bed. So it protects how parts fit together. It protects the shape of functional products. And this is an automatic right which comes under the Copyright Designs and Patent Act 1988, and it arises automatically under that statute. So what that protection does is it prevents anyone else from copying or using your design for 10 years from when you first marketed the product, or 15 years from when you first created the design document, the lesser kind of number of years there. However, if someone were to approach you in your last 5 years of protection and say, I'd really like to start using your design, I think I can, you know, improve it, or I'd like to start using your design for my own purposes, then the law states that you have to grant them a license. And there is an online form which you can use to ask the design owner to grant you that license. There we are. So I'm now going to contradict myself a little bit, because this is a hangover from European Union law, which it's a right that's been created since we Brexited. So we do actually have an unregistered automatic right of protection for the appearance of designs. However, it's only 3 years from the date you make the design public. So whether you make that design, the design drawing public, or you put that product out on the market. So if you don't find out until 4 years later that someone's using your design, then you can't rely on that design right. So registration is always better, because you've got that for 25 years, subject to you renewing it, of course. Okay. Right, patents. Sitting comfortably on your chairs, on your quirky chairs. So it's probably unlikely that any chairs are patented, but you never know, because we've got like electronic recliner chairs now, and we've got chairs with USB ports in them. So who knows? We might have chairs that are patented out there. So a patent is how something works. It's an invention. So think Dyson, think your iPhone, think your drones, and think of your good old faithful rotary washing line that you have in the garden. That was once upon a time patented. So patents are very, very specialist. So although we as solicitors can give you some really general advice about patents and the protection and the requirements, we would always refer you to a patent attorney. There are patent attorneys out there for every kind of invention. For example, there might be mechanical attorneys, electrical attorneys, software attorneys, and so on. So a patent gives you a monopoly over your invention and excludes others from using it as described and claimed in your patent. So again, this is why it's so important to seek specialist knowledge, because your patent protection is only as good as how the patent is described and claimed in your patent application. So you've got to describe the patent, you've got to describe what it does, and you've got to describe, or claim what the invention does. So it's really important that your patent attorney describes and claims the invention properly. Otherwise, you may not have a few words wrong or a few things not described. You might not have the patent protection that you think you do have. So really, really key to get good legal advice there, or seek patent attorney advice. So for a UK patent, you have 20 years protection. And again, it's renewable every 5 years for a fee. So in order for your invention to be patentable, it must be new, must be novel, and not form the state of the art. And when I say state of the art here, I don't mean, oh my God, your headphones are state of the art. It means the current state of the market. So what inventions are already out there on the market? It can't be obvious. So if I were to, you know, pick up a patented product and go, oh, if I just tweaked it that way, or that bit goes there instead, then it can do this. It can't really be obvious or naturally flow from an existing patent. And it must be capable of industrial application, as in it must be able to be manufactured and put out there to market. Now, what I would like to say at this point is be so careful about who you disclose your invention to without an NDA, a non-disclosure agreement, because if you show your patent drawings or disclose, you know, your idea about your invention to anyone, then all of a sudden your invention drawings or your idea is out there in the public domain, and therefore it forms state of the art. So it could affect whether your invention is new. So if you do need to speak to anyone about your patent idea or patent design, then please make sure you they are a professional bound by a duty of confidence, or you have an NDA in place. So while patents are great, because, you know, a lot of people, you can license your patent for royalties, they are quite costly. So just a patent in the UK, you're probably looking upwards of £10,000. And that's not the application fees at the Intellectual Property Office. That's probably the amount of professional fees that you would need to make sure, you know, your patent application, the description and the claims in that application are correct. So it's more professional fees.
But presumably
And
worth
again,
it, yeah, in the long run to protect your idea or invention.
Absolutely worth it. If you have got a crazy, awesome invention, it will be absolutely worth it. And I thought I would share some interesting patents with you. So we've got the good old light bulb from Thomas Edison. Who knew the paperclip was once upon a time patented? The everyday items we take for granted. And really interesting, Michael Jackson patented his anti-gravity illusion. So I can't remember what music video. Was it Smooth Criminal?
Gotta
Maybe
be Smooth Criminal or a bit of Bad.
Yeah. I think it was Smooth Criminal, when he's in the white suit, he's got the white hat and he does the famous lean. It's kind of the video where it's kind of like Bugsby gangster. And yeah, he does the famous lean, and who knew, but there was actually a piece of equipment that entitled them to film that whilst creating an optical illusion, so it looked like he wasn't leaning on anything. And obviously that was before the days that we could, you know, take things out of videos and tweak them. So, but yeah, it's actually patented in his own name, so really interesting.
Thanks, Abby. I think just before we move on, I think one, you've just been telling us of all the benefits here, and particularly of registering designs. I was just wondering if there were any negatives that people should look out for, or if it's all good to go.
Registered designs. So yes, if we're talking about clothing or wallpaper designs, or for example the Twinings, different flavored designs, then I cannot think of any negatives at all. Super quick, super cost effective, great deterrent to prevent others from copying it. The only time that I would be slightly cautious is if you are choosing to register a CAD drawing. So a CAD drawing is going to be more intimate, it might show dimensions, and it will go into more detail about how your product is put together.
Yeah.
And so with that in mind, bear in mind that having a registered design is a public document. Your design will be in the public domain, and therefore, you know, we've had clients before, Ramona, who, talking about the pros and cons, they've actually decided not to register it as a design because they would rather their competitors didn't see, you know, the design of their products.
Yeah, and keep it safe from public eye. I see that. Yeah.
Good, cool. So hope you're sitting comfortably on your registered design and unregistered design right, and possibly patented chairs. There we go.
Copyright.
So refreshments, branding, chairs, designs and patents. Looking forward to this protected presentation is all about copyright. Because this presentation is actually presented by copyright, and at the very, very first slide, it actually said Thrings copyright 2022. I bet no one spotted that. Anyway, so copyright is a right which exists under the good old Copyright Designs and Patent Act 1988, the same act which is for unregistered designs. And lots of different works are protected by copyright. So you have literary works, which is basically anything written down, whether that's text, in a book, in a Word document, text on your website, the software code behind your website, information in databases, that's all protected as a literary works. Dramatic works are also protected, so theatre plays, musical works, meaning the score, because the lyrics would be classed as a literary work, and artistic works. So think pictures, paintings, photos, and they don't have to be any good. So irrespective of artistic quality, as soon as something is written down, something is drawn, a picture is taken, then copyright will exist in that work. Oh, another myth buster. So again, because copyright exists under the Copyright Designs and Patent Act 1988, there's no need to register, as protection will arise automatically as soon as the picture, painting, text is created. However, what I would say is if we do have any businesses listening who have a wider scope or operate outside the UK in different territories, then it would be really good to seek local legal advice, because there are some territories, America is one that I can think of straight away, that there are some types of works that do have to be registered. Okay, so there are some types of copyrighted works in America and possibly other countries that do need to be registered. So we would always say, please, please, please take local advice if you do businesses in other countries. So who owns the copyright? So the author, whoever creates the works, is the first owner. And I remember a couple of years ago, there was a guy who went out into the wilderness somewhere, and a monkey got hold of his camera and took a picture. And therefore, there was some great kind of there's some great stuff in the press about, oh my goodness, is the photographer actually the owner of the copyright in this picture? Surely the monkey must own it. And it was great fun to read about and at the time. But unfortunately, everyone, if you train your dog to press the button on your camera, you will still own it, because the owner has to be a natural person. So sorry to disappoint you.
I was going to say, I wonder if we could say they were employees.
Yes, yeah, because that is the next exception. So whoever creates the work is the author and the first owner. The only exception to that is if there's an employee-employer relationship, and if your employees create in the normal course of their employment duties any works, then the law states that the employer will be the owner of that work. So therefore, if there's any businesses listening now who have self-employed contractors, or maybe they instruct a third party to create a work for them, whether that's a picture, a painting. We often see people outsourcing website design or branding. Then it's so important that in your contracts with your contractors, and in your terms and conditions of purchase, or in the contract with the third parties that you've engaged to create the work, it's so important that in that contract, they assign the copyright to the business, because otherwise they will own the copyright, and it's just so much better if we own it. And of course, if you need help with your contracts or reviewing any contracts, then absolutely we are here to help.
Abby, it didn't take too long for you to mention contracts.
I know, I'm such a contract geek. Okay, so how long does copyright protection last for? A decent amount of time, actually. So generally speaking, it's 70 years from the author's death. So that's why, you know, production companies or, you know, deceased singers' estates are still reaping the rewards of the songs and the music of artists from long ago. The only general exception is any computer generated literary, dramatic, musical or artistic works. That's just slightly less time, 50 years. So again, I say deterrent a lot on this presentation, but I cannot emphasize enough how effective these copyrights, these intellectual property protections are in deterring, you know, people from jumping on your bandwagon or trying to copy your, you know, your things that you've created for your business. So we can use copyright notice as the perfect deterrent on our marketing materials, on our websites, on our quotes, and it's the little c in the circle. So example here, and at the front on the first slide, we've got Copyright Things LLP 2022. So you basically use the copyright circle to put people on notice that it's copyrighted material, the name of your business entity, the year it was created, and all rights reserved, just to make sure we're reserving any other rights we may have too.
Thanks.
One thing I wanted to add here as well is that you might be a sole trader at the moment who just operating under your personal name. If you ever decide to incorporate a company, then it's really, really important that you assign the copyright and all intellectual property from you as a person into your new company, because your new company is going to be a brand new legal entity. So it's really important that you assign ownership in your creations to your new company. And again, we can help with that.
Awesome. That's a really good point. And I guess from you've used the word deterrent a lot. From a litigator's perspective, it's because you don't want your clients ending up with needing litigation help, presumably,
Yes.
which is a shame for me. But I did have, and I did have a client come to me the other day, and I thought I would just share this and ask your view, Abby, because I wonder if it's something that our listeners might have come across. So I had a business owner come to me the other day and say, someone has used my photographs. I had them on my Facebook page and someone has used them. I said, what photos are these? Thinking they must be really creative.
Yeah.
And the client was a builder and their pictures of building works. And I thought, goodness me, well, he wants to protect those anyway. That sounds really dull. But obviously, it's showing his craft, his trade, his business. So I handed them over to our intellectual property experts. And the answer, Abby, is, can you use anyone else's photo from the internet?
Oh, good question. This happens, or we get asked about this quite a lot, don't we? Absolutely no. Please, please, please. You know, there's a really common misconception actually that if something's on the internet, it's in the public domain, so it must be free to use. No, 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 no. That is not correct. If something's on the internet, just because it's on the internet, someone will still own it and someone will still own the copyright in that picture, in that text, in that image, in whatever you're using. And, you know, back in the day when I used to do a little bit of litigation, Ramona, I would act for so many people who would say, oh, please, can you help me? I've received a letter through the door asking me to pay, you know, fair chunk of money because I've used the photograph without permission. And you know, and normally it's from Getty Images. I'm sure we've heard of Getty Images. There's other kind of photo stockists as well. And you know, and the internet is actually run by bots now. You know, so these companies send out their little bots into the internet and they will kind of screen all the internet pages to look for text, pictures, you know, images, photographs that have been used without permission. And then that's why you get the naughty, the horrible letter through the door. And these companies are quite clever actually, because the license fee that they ask of you in order for your past use and your continued use of that image is what is probably a little bit less than it would take to get, you know, a couple of hours legal advice. So they are quite clever. So please, please, please don't take anything off the internet, because it will be owned by someone. The copyright in that works will be owned by someone. And if you do use something without someone's permission, it's likely that you will get a nasty letter through the door due to the power of bots.
Brilliant. Thanks, Abby.
Okay. So we've enjoyed our refreshments. We've talked about branding. We've talked about, we're sitting comfortably on our chairs, which is all about registered designs and patents. We've talked about this protected presentation that you can't tell anyone about. So this next section is all about confidentiality. Mythbuster. Woo, love a good Mythbuster. Okay, so
we need a little jingle. Mythbuster.
Yeah, maybe we should trademark that, Ramona.
And we should.
So you cannot protect an idea. You can only prevent people that you tell about your idea from sharing it with others. Okay, so it's only when your idea starts to develop into a tangible form and different intellectual property protections start to attach to those forms, that's when those protections kick in. All right, so when you think of a brand name, you can register that as a trademark. When you know, put pen to paper and you create a design, you'll have, you know, design right, and you may want to register that design as well. Once you write it down, you've got copyright protection. All right, but if it's just an idea in your head that you want to talk to someone about, you can't really protect that, or it's really hard to protect that. So an example is, I've got this crazy idea. I want to start teaching kids how to cook and do cookery school. And I'm going to call it Crumbs. And I'm and I'm working with a manufacturer, and they're going to help me design and manufacture some, you know, child-friendly kitchen utensils and tools and things. All right. I go away to a business angel in a Dragon's Den. I pitch my idea, and then a couple of weeks later, there's a website called Crumbles, and guess what? It's cookery lessons for kids. So, however, if I had trademark Crumbs, if I had design rights or registered designs in those kitchen utensils, if I'd also had a really good contract with the utensils manufacturer, I would have protection. But if I'm just going off to a Dragon's Den event and telling them about my idea, then they can absolutely run with it. So what can we do? Well, we can absolutely get them to sign a non-disclosure agreement, also known as confidentiality agreement. Because what this does is it means they're signing up to a contract where they are obligated to not share your idea with anyone else, unless there's certain permissions in the NDA itself. It's that D word again. It's the perfect deterrent for them not to do it. And I also think that if someone's signing a legal document, it helps to focus their mind and think, okay, I better take this seriously. I better not share this information with anyone. Even though it's a fantastic idea and I wish I'd thought of Crumbs, I better not share this. All right. Ramona, this is absolutely your bag more than mine. But if someone breaches the confidentiality agreement, you can normally claim pretty decent amount of damages, and you can even apply to the court for an injunction to stop them using the confidential information that they've run away with.
Absolutely, and the sooner they do that, the better, really, to stop any further damages.
Yeah. And again, we're here to help. So, you know, we can help make sure that you've got the right type of NDA in place, and it's got the right protections for you. Okay. However, sometimes something is so secret that we don't even want to share it, even if it's with a confidentiality agreement or NDA in place. And when something is so secret to a business, or, you know, that information is so crucial, then that's called a trade secret. And examples here are, you know, the Google algorithm and the famous recipes of Coca-Cola and the Colonel's secret recipe. Although I did go to a vegan restaurant the other day, and I had these kind of battered mushrooms, and the waiter said to me, the KFC secret recipe's been leaked, so I hope you enjoy it because it's kind of based on that. Who knew? I might have to look into that in a bit more detail. But basically, we, these are that information, or trade secrets, is internal information that we don't want to pass on to anyone outside or external to our own business. So how businesses deal with this is they have strict internal procedures to make sure employees don't take information home. They might have super duper technology to protect the information if they do have anyone working from home. They will have really strict employment contracts. They might have security. Think of the massive Google building. You're going to have security checks in and out when you go out. So they have all of these measures to keep that information in-house and as secret as possible. So some little fun trade secrets for you. Iron Brew, the famous Scottish drink, apparently only known to 3 people in the world: former chairman, 1 director, and the chairman's daughter. Allegedly, again, might just be an urban legend, but apparently the recipe is locked in a Swiss vault. Who knew? Trade secrets always seem to be about food. I've got no problem with that. I love food. But Liam Perrin's Worcestershire, as the Americans would say, Worcestershire. I can't even say it now. Worcestershire sauce. Also a trade. The recipe also a trade secret. Liam Perrin's was bought by the Heinz family in 2005, and again, only a handful of people know it, and it's kept firmly under lock and key by Heinz as a trade secret.
I do find it all really interesting, Abby, when it comes to all the trade secrets. But I think the more common thing that comes across my desk quite often is where you have employees or business partners who absolutely do know, and they've had to know, and rightly know, the business trade secret, the business know-how. And inevitably, sometimes those parties will break up, will fall apart, will leave. And the best way to protect that business know-how, those trade secrets, Abby, is?
Yes. So it's all down to your employment contracts. So if someone does know a trade secret and got, for whatever reason, they do decide to leave the business, then we can just make sure that we have the right employment provisions in our contracts. So, for example, we might want to put them on garden leave straight away to stop them getting any more information, because, particularly senior people, they might have quite a long notice period. So that's kind of a legal way, but also a practical way that we could do that. So we'd have to allow for garden leave and pay in the contract. But one of the main ones is restrictive covenants. So again, Thrings employment lawyers can help any businesses listening. We need to make sure that in your employment contracts that if someone leaves, the confidential information that they have learned should really go on in, the duty of confidence there should go on indefinitely. They shouldn't tell anyone about the information that they've learnt whilst in our employment. And secondly, there can be other restrictive covenants too. So we don't want them to work for a competitor for a certain amount of time, because, that would be pretty obvious if they start working for a competitor, and, more likely to reveal our trade secrets if it is a competitor. Yeah, so those are the 2 key things that come to mind. So garden leave, and just making sure we've got those, post-termination provisions in the employment contracts.
And if necessary, we can help enforce it. I've had to undertake injunctions before for clients and claims for damages, again, where there looks like there's been breaches or potential breaches of such important information for your business.
Yeah, absolutely, we can help. Okay, so we hope that my quirky introduction and presentation has helped you to identify the intellectual property rights which exist in your business. We've had the refreshments for brands and trademarks. We've had the chairs for designs and patents. This presentation is protected by copyright, and we've also talked to you about practical steps around confidentiality too. So we hope that, you know, our little stories and the introduction will help you to identify what intellectual property exists in your own businesses. And once you do identify them, make sure if anything needs to be registered, you get those registrations in as soon as you can. It's that great D word again, you know, intellectual property rights and advertising registration numbers or using TMs are in the circles and C in circles are the perfect deterrent, and just make people take notice that, you know, you understand your rights. And again, it deters them from jumping on your bandwagon and copying your materials. And having a nice intellectual property portfolio in place is going to be really attractive to investors. So in the event that you need to raise funds for your business, or when it's the right time to exit, a potential buyer or investor is going to make sure that firstly your brand name is protected as a trademark, and again you have all the other protections in place to make sure the business is as valuable and protected as it can be. Remember to exploit your IP. You know, depending on what you do in your business model, you might be able to license your IP. If you're a software developer, maybe you can license an app. Maybe you can license or sell photographs. Franchising is basically the licensing of your brand name and the licensing of your internal business methods of how you operate your business. And this is all in exchange for license fees and royalties. So you can, you know, create income from your IP. And again, this is much more Ramona's bag, but make sure that once you know your IP and you've got the right protections in place, that you're not afraid to enforce it. Because, you know, if you let potential infringers get away with copying any of your materials, then it's just going to decrease the value of your brand and your business.
Absolutely.
So I hope that's been really helpful, Ramona.
Yeah, I mean, frankly, really super helpful, and hopefully really helpful for all those listening. You've given us a load of information there, and so just really in summary, some practical steps and some top tips to take away with you today. Really, firstly, understand what IP exists in your business, and then take legal advice super early in order to protect that IP that you've identified. Obviously, be careful in the process. Revealing IP can scupper protection there. Think of the Dragon's Den example that Abby gave us. Make sure that any third-party creators of your IP assign the ownership to you under the contract terms. So it's always worth, if in doubt, getting a third-party eye, getting Abby eye over the contract, because she just loves them. And then finally, making sure that you have all your key documents in place. And if necessary, it's definitely worth taking legal advice over them to make sure they say what you think they say. So that's documents including NDAs, lovely, we love terms and conditions, purchasing license agreements, branding policies, and any infringement letters that you're worried about that you might have received through the door. Obviously, if in doubt, we're here to help, both in terms of setting up the protection in the first place, enforcing it, or defending it. So any questions, there's our contact details, and we love to talk, so do get in touch. Thank you very much.
Thank you for listening.
Thanks, Abby. Bye all.
Thanks, Ramona. Bye-bye.